let me get Sidharth Luthra's take on this, all these changes which are being described as a massive overhaul of the judicial system, legal system. We are hearing two top lawyers say that it seems to have been brought about in haste, may not actually see the system being improved, seeks to discredit the system. Where do you come out on this, Sidharth?
This exercise has been undertaken for a while, and there has been an attempt to make the Indian Penal Code a little more comprehensive. They've added terrorist offences, corruption offences, snatching, organized crime, and they've taken the definition clauses and they've put them in one provision to make it perhaps easier to read. What I find on the reading is some of the illustrations also and examples have been updated, but what I find is that essentially it is a reworking of the time and tested code. Other nations have also done this exercise. So the Indian Penal Code as it stood has been used as a template which has been modified by other nations to perhaps domesticize it a little. It has been spoken of to, to get rid of the colonial legacy. But if you look at this substantively, let's look at the definition of, let's say, culpable homicide or murder. It's substantially the same. Hurt, grievous hurt is substantially the same. And some concerns of the legislature in terms of additional offences have been added. So that's so far as the Indian Penal Code is concerned. Then you have, I mean, for me, speaking for myself, one of the concerns that arises from this is that by adding organized crime, by adding terrorist offences, by adding corruption offences, you are bringing them in this code, in this Sanhita, but you are not removing the provisions or the laws which contain these. That is, for example, Maharashtra Control of Organized Crime Act. You have not removed the Prevention of Corruption Act or the provisions in the Unlawful Activities Prevention Act. Then again, Unlawful Activities Prevention Act offences are investigated by NIA. So there is going to be a peculiar interface between this legislation and the NIA Act, and that is not being dealt with in the procedural law as well.
Okay. Aman Lekhi, so one of the things which was said was that sedition has been done away with, but if you see the fine print, provisions which amount to actually dealing with offences similar to sedition still exist even in the new law. So is it actually doing away with sedition, which is what the government had publicly said it intends to do? Is it just finding another way of inserting virtually the same provisions without calling it sedition? Aman Lekhi?
It's amusing to read that particular provision. It's hilarious. The lack of seriousness in drafting important provisions and understanding both of law and language. It is grammatical. The semicolon is at the place it shouldn't be, and apart from altogether, the most substantial issue here is subversive activity, which I said at the beginning. Now, what activity can have a very wide connotation. It can be open, it can be secret, it can be peaceful, it may be ideological, it may be political, it may be criminal. What is subversion? The subversion, you go to read the mind of the person who is invoking the law, or this is an objective standard by which you apply the law. If you want to substitute a provision by another provision, you have to set out the standards for the purpose of application of that provision. And then that is the prime obligation of a penal provision, so as to put people to notice as to what kind of culpable conduct will actually be recognized as punishable. If you look at this particular definition, it lacks that particular direction altogether. I don't joke when I say it's the poor English. Point is, that's the language in which the offence is drafted, and therefore the means to understand it. Both in law and in language, this position is wanting. Now here, that the duplicity of the government becomes obvious. The government was very keen, and rightly, I am in favor of sedition personally, I may be in minority, I think sedition is necessary for a country, but be that as it may, that's aside. The government defended sedition. The government said that sedition is necessary. Now when you bring about this particular change to alter the law, in my opinion there is no need to alter the law itself. For public acceptability, you say that sedition is diluted, but the provision which is there expands that particular offence, and while expanding the profession is without the limitation and the protection of the old one. So we're in a worse situation now than we were earlier.
Dr. Abhishek Manu Singhvi joins us, senior Congress leader, one of the top jurists in the country. Dr. Singhvi, you know, we are hearing from the likes of Aman Lekhi, Sanjay Hegde, Sidharth Luthra, raising questions about the manner in which the new changes have been brought about and what this means for the legal system. As a top jurist, if you try and put your political hat on the side for a moment, do you think that these changes actually simplify, de-jargonize and potentially speed up the Indian judicial process?
There is somebody competing in the voice system with me, Rahul, but that apart, I think I would hate anybody to speak in a broad, blanket political manner on a matter like this. It requires a nitty-gritty analysis. Let me say at the outset, anyone and everyone, including myself, is really giving a more superficial and tentative view, because here you have three big acts, one totaling 356 sections, another 533 sections, and a third 170. To be able to compare the changes of the current with the old, to be able to analyze them and to give you a very good analytical, comprehensive answer, I think is beyond the reach of most, including geniuses, and I don't pretend to be one. So I think we must be very careful, and I think it must await a more detailed analysis. I'm writing an article on this also in the near future, which will be a little more pointed and better than today. But having given that disclaimer at the outset, can I tell you three or four points which I think stare you in the face and don't make very good reading? And I have nothing to do with politics when I speak about three acts. First, I am very disappointed at one thing. I don't think it has struck anybody that a change, if it is done for minor things or just for the sake of change, of such a nature, after all, one of them tinkers and touches 175 sections of the old IPC, the Bharatiya Sanhita, the Nyaya Sanhita. It touches and amends little or more 175 sections. The CrPC counterpart, the Nagrik Suraksha Sanhita, touches 160, and the third one touches almost 23 or 30, the counterpart of the Evidence Act. Now, the point I'm making is, when you tinker with existing statutes, you lead to an explosion of litigation. Unintended, unplanned, unanticipated, unforeseen. Everything in the past technically gets erased. Each section has 100 case law. Now it is open to clever lawyers and even cleverer litigants to say that established judgments, established jurisprudence should be ignored, and you should reinvent the wheel and decide de novo because the section is new. You cannot imagine the kind of explosion of litigation this will lead to, a thing which is completely forgotten, point one. Point two, sedition is a big, big disappointment. Indeed, I would say it's a fraud on power. I just heard some of my friends in the last part, but I would like to add to what they are saying. The section, and I will not read it to bore your viewers, I've got it in front of me. It was earlier challenged, and a statement was made in the Supreme Court that for the time being we will not activate it, we will not use it. Now, the version you have now is far vaguer, far broader, and far more all-encompassing, which are the three precise reasons why this whole crusade against sedition was on in our country, and which is the reason why the Supreme Court was about to give a stay, but desisted when the government said, for the time being, we will not act on this existing 124A. Now, this is actually a fraud on power, because this is very vague. Apart from all the grammatical and the English errors, I am saying that this is really not bringing in sedition from the back door. It is enhancing and enlarging sedition with many more unintended things, giving it much more power, and shows the mindset of what I call at the moment a clear control freak impulse. And they've done it very surreptitiously, in fact, over cleverly, disingenuously. While on the left side pretending not to do it, on the right side actually bringing in. The Home Minister specifically made a statement that we've done away with sedition. Well, that may be technically true,